Okay, so today we are going to be discussing the Cayman Islands beneficial ownership regime changes. This is going to greatly impact corporate service providers and a lot of Cayman companies. And we are very lucky to have Colm and Andrew join us from Walker's regulatory and advisory team based in the Cayman Islands. And I think you guys are pretty much the experts. So thank you for giving us this time of yours. We really do appreciate that. Before we begin, there is a little bit of housekeeping. This is just to remind everybody that this is training and informational purposes only. It is not deemed legal advice. It will last approximately 1 hour. I'm pretty good about not making this go over too much. There is a certificate of attendance that will be automatically generated to any attendees of a live broadcast only. So if you are watching the recording after the 18th of September 2024, you will not get that certificate. We do have some Q&A at the end. If you have a question that you would like to post, please use the question box. I don't think the chat box works for these webinars. There is one handout. Andrew, were we good to go with that handout? So
I think we'll send that out. We'll send that out following the presentation.
you'll send it out following the presentation. Okay, so we do send out the recording as well as the slides, so there will be a handout for that. That will come in a couple of days. And then let's go ahead and get started with some quick poll questions, Tom. And not to take too much time, but please just kind of take a second or two, answer this question. We just want to know if you're joining us, what is your role? Are you a corporate service provider? Are you a Cayman company director or senior manager, or maybe a fund administrator or a trustee? And you're trying to find out what your legal obligations are. Or maybe you have no connection to Cayman and you are just listening in to kind of see what other jurisdictions are doing. Perfectly fine. And of course, if you are a regulator or other government official, or you might be somebody else. Maybe you're an IT professional or a consultant or an investor. So please take a moment to answer that. Great. Yep, we have about 31% of you are Cayman corporate service providers, 19% are company directors, senior managers, fund administrators, or trustees. And then we've got 10% that are regulators or other government officials. Thank you very much. So let's go ahead to the next slide, Tom. So there's three more of these poll questions. We just want to kind of bust through. Again, just help us understand your current understanding of the beneficial ownership regime. So we're just kind of testing you right now. What is the relevant percentage for the purposes of the beneficial ownership regime in the Cayman Islands? Great. We are looking good. So let's go ahead. Yeah, we've got about 60% of you are saying it's 25%. About 30% of you are saying it's 10%. And then it's split between the others. So there is some confusion there if it's a 10% or 25%, which I'm sure Andrew and Colm will clarify for us. And the next poll question is who is the competent authority under the Beneficial Ownership Transparency Act of the Cayman Islands? So we've got a few options. We've got SEMA, the Civil Aviation Authority, the General Registry, or the Financial Reporting Authority. All right. And so far, we're looking at about, let me see, just under 50% are saying it's SEMA, that's the Cayman Islands Mandatory Authority. 40% are saying it's the General Registry, and 16% are saying it's the FRU. Only 1% is saying it's the Civil Aviation Authority. So again, Colm, Andrew, you'll be able to clarify that. And last poll question, before we begin, our trust and scope for the Beneficial Transparency Act. Oh, good mix here. We're currently showing about 65% saying yes, and 35% are saying no. So again, Andrew and Colm, help you guys to see where the audience is.
Great stuff. Thank you.
Thank you. Yes, actually, that's some really interesting. That's some really interesting feedback right off the bat, actually, for everyone.
Yeah.
So it's probably worth talking about those straight away, isn't it? Do you think that's
Yeah, surely I think that's a good idea.
Yeah, and
All
I
right.
mean,
Yeah,
yeah, thank
fantastic.
you.
So again, just to introduce those who aren't familiar, so we have Colm and Andrew. You're both down in Cayman, and you are partners at Walkers, and you're with the Regulatory and Risk Advisory team. My name is Kimberly Smith. For those of you who don't know me, I'm the founder of Silo Compliance System. I used to be an AML compliance officer and MLRO. It's based in London, and I worked for a corporate service provider and law firm. So I'm very familiar with kind of what kind of goes on in the background as far as the workflows. And it's my background was that from those kind of frustrations or my desire for more efficiency is what I like to say. I founded Silo Compliance System, which is used now in many places by corporate service providers and other industries. So our agenda today, we're going to have a quick overview by Colm and Andrew. They are going to go over the new regime implications on SEMA registered funds, some non-SEMA registered entities, and the beneficial owners that are identified. Help us identify or define who is a beneficial owner, the obligations, and I believe that's going to be obligations of both the Cayman entity and the CSP, the corporate services providers, as well as the beneficial owners, and who can access beneficial ownership, which that came up a question for me this morning, a few hours ago. Somebody was asking about who was going to have access to it. What happens if there is a failure to comply? There is some Q&A time. I put time permitting, but I think we're going to have a little bit of time. And then, of course, we'll announce our next Gray Matters webinar. So without any further ado, Colm, Andrew, thank you so much. I am going to let you take it from here. I am not going to interrupt. I'm even going to turn my mic off. And I will, like I said, I'll ask the questions, pose any questions at the end during Q&A. And just let me know if you need me to move a slide, okay?
Perfect. Thank you very much, Kimberly. We can probably click over onto the first slide just so it's up there on screen. But some interesting polling data that I think it's worth just talking to briefly in the first instance there. Interesting to see 60% coming in for that 25% threshold. Not too surprising, perhaps, given we've got a couple of main thresholds here in the Cayman Islands. For this regime, for the Beneficial Ownership Transparency Act, for its purposes, the percentage we're looking at there is 25% rather than the lower 10% that we look at for the AML regime. So it's just worth remembering and keeping in mind as you're advising and looking at these that there is that distinction, there is that shift, there is this higher threshold. We'll talk to all these in more detail later, but it's worth just talking about those polling points because some of them are interesting. 6% coming back with that, which makes sense, but just worth remembering that there is that split there. On the authority, given we had the 50% looking to the monetary authority, funnily enough, this is a regime that links back to the general registry. And this is their regime rather than the regime of the monetary authority, which is just worth remembering. It's worth remembering that's who registered office providers are going to be dealing with and addressing. It is the general registry's regime. It's not a regime that originates out of the monetary authority, and therefore there is some difference there.
And I think just for context and background, the previous beneficial ownership requirements were all housed in the Companies Act. So therefore the nexus between the general registry as the registrar of companies and other entities in the Cayman Islands is the natural place for these competent authority obligations to lie. And also bearing in mind that I'm sure many of you are joining in the context of Cayman Islands investment funds now being in scope, but there have been hundreds of thousands of beneficial ownership registers being returned to the general registry since the commencement of the legislation a number of years ago. So it's not something that's conceptually new for the islands. And I guess the reason that we're having the session here today is that it's becoming front and center for many of the on-island and off-island participants who have access to use or operate through Cayman Islands investment funds.
Yeah, absolutely. And that last one there, trusts, with 65 people saying that they are in scope. It was partnerships that have been brought into scope by this new beneficial ownership transparency regime. Trusts remain out of scope. Yes, you might have to think about them in the context of identifying beneficial owners, but they are not in scope for the purpose of this regime. So worth remembering that those trusts will remain out of scope.
Well, a lot of trustees will be in scope,
Yes.
because the trustees are actually corporate entities. So it's a little bit confusing in that sense, in that trustees will be obliged to consider these issues. And I'm sure many of you on the call or on the session are actually working in that area. So trusts as entities themselves are not, but trustees will have to consider whether they have obligations, particularly if they hold other licenses and permissions and the CSP headings.
But yes, a few little good questions there just to get everyone thinking. And with that, we should roll straight into a bit of an overview. And a small anecdote from me, because I love telling this anecdote, and apologies to anyone who's heard it before. I've been looking at beneficial ownership for so long, and it was one of the first things I looked at when I came to the islands about 7.5 years ago now, going on 8. And I remember I was merrily dispatched over to the government to discuss beneficial ownership. I hadn't been here at Walkers very long, and I was quite nervous about it, and I was suited as I am now. And I got over to the government office, and we're all sat around in a room in the government building across from Walkers. And the I've got my list of things that I want to say and my points I want to make on the new beneficial ownership regime as it was then, and how it's going to be implemented. And I really wanted to make sure that everyone, the collar was feeling a bit tight. I'm sitting there and I'm looking at that, and the room starts moving. I'm sitting there thinking, oh no, this is just dreadful. I'm going to have some sort of stroke over the beneficial ownership regime. I'm never going to be able to live this down. And I was the only person in that room who was relieved to find out that everyone else could see the room shaking as well, because we were having something of an earthquake that morning. And so we all rushed outside, and we all stood outside as people are. And then about 10 minutes later, after it had stopped, I was saying, well, we have to go back inside and discuss the beneficial ownership regime. And someone very calmly sort of took me aside and assumed I was in shock and explained to me, sir, that there's just been an earthquake. You need to go home and check it. So, no, beneficial ownership regime. Sir, there's been an earthquake. I know there's been an earthquake. The point is, this is slightly close to my heart. But anyway, I'm pleased to say, hopefully we'll have no such interruptions today as we talk about the latest iteration of the Beneficial Ownership Transparency Act. To Colin's very good point a few minutes ago there, this is a regime that follows on from a regime that used to be within the Companies Act. So it used to only apply to companies in that context, limited liability companies. We're very pleased to see it now, well, we as lawyers, I suppose, but we're very pleased to see it in lots of ways, codified into its own piece of legislation. So that's why you now have the Beneficial Ownership Transparency Act. So it is a new act, but the regime itself is not new because it was codified elsewhere. That does come with its benefits. So despite the fact that a lot of what we'll be talking about will be an expansion of scope in a few areas, the fact that it is now within its own act does come with its benefits. It should be a bit more of a fluid regime. It's very hard to change or amend as it was codified in the Companies Act, the Companies Act being sort of the most complicated piece of legislation we have here in Cayman. That makes it a very difficult piece of legislation to amend for all the obvious reasons. So we now have it in its own Beneficial Ownership Transparency Act. That is a 2023 piece of legislation. But it did not come into force. It only came into force, as you can all see there on the slides, on the 31st of July 2024. But one of the key sort of messages here is that we have this understanding that it is not going to be enforced. And indeed, all reporting at the moment is currently suspended until 1 January 2025. That's a blessing in lots of respects. It allows everyone to get up to speed over the next few months. But I'm conscious we're now in September. We do have plenty of time for both RO providers and clients and other counterparties listening in to bring ourselves into compliance. But these months need to be used to make sure we meet that 1 Jan 2025 deadline. I'm conscious that when you put 2025 on something, there's a bit of a human inclination to say, well, we'll deal with that in 2025, but really this is a 2024 job. You've also got the regulations there, which aren't to be ignored because they contain some important points that we'll come on to later, and also the guidance complying with beneficial ownership obligations. And we're terribly grateful to the government for the time spent putting together that set of guidance. Let's open on to the next slide, please. Thank you. So few sort of few more overview points to continue there. The reporting for already in scope entities will continue once the reporting obligations recommence. So just to remind, it's a reminder that for some this is new ground, but for a lot of entities in the jurisdiction, a lot of companies, this will not be new ground. And even for corporate service providers, and to be honest, for those using corporate service providers, it's a nice reminder that we as a jurisdiction have been complying with this regime for a number of years now, even if that's only at the level of filing those exemptions, that we have been doing so. But we're now going to move on, and this is a continuation. So the second bullet point there is the one that most people will remember this regime for, is that the previous exemptions have fallen away and been replaced with minimum information requirements. As a jurisdiction, the old regime had a lot of exemptions from the beneficial ownership regime. One of the, it was almost defined by having a number of exemptions, and I believe the official statistics were that 95% of the companies that would have otherwise fallen under the regime were exempted from it. And therefore, optically, externally to the Cayman Islands, looking in, to the international agencies looking into the Cayman Islands, when we say we have a beneficial ownership regime, it doesn't help if we're then saying, but we exempt 95% of our companies. So we're looking to a different approach going forward, and that is part of what this regime brings us to. In-scope entities will need to be aware of penalties for compliance. This is a regime where we have seen penalties handed out, so it is a regime to be conscious of. And then lastly, there, corporate service providers engaged to assist and update and help and assist with that data collection. It is all to be done through the registered office providers. They are the access to the online portals that have been set up within government, within the registry, to maintain and house this beneficial ownership register, and they are going to be your point of contact going forward.
Next slide, please, Kimberly. So just to add to what Andrew has said, it is something that is already in existence. It's just being built out to accommodate the extra in-scope entities. There are, however, some exemptions of sorts remaining, and one in particular, which I'm assuming is of interest to many of you in attendance, is that CIMA registered investment funds, be it private funds or mutual funds, can benefit from what's referred to as an alternative route to compliance. And they can identify a Cayman Islands-based service provider as defined in the Act as a party who is authorised to provide information under the auspices of the Act. So that would be registered office service provider or another party that is suitably authorised. We'll discuss that in a little bit more detail as to what the practicalities are. From a market overview perspective, we're aware that some parties have confirmed to clients that they are actually going to provide this ability, but there is also some time being taken for other entities to consider whether or not it's something that they're going to be able to offer on a commercial basis. So Walkers, for instance, as a registered office service provider, will be providing this for clients, and as such, we have worked on the approach internally as to the functioning of how that contact person, which we'll deal with in some of the further slides, will actually be dealt with on a go-forward basis. Entities that are not CIMA registered, such as general partners, trading subsidiaries, Cayman Islands registered persons, for any of you that have an exposure to that type of entity, those are not entities that can benefit from the alternative route to compliance. And then just in the block capitals as to who beneficial owners are. So beneficial owners of such entities, which is essentially every entity that can benefit from an alternative route to compliance, isn't a subsidiary of a governmental agency, isn't a listed company or a subsidiary of a listed company. These are defined in the legislation, and you'll see them. And actually, just to give a little bit of extra colour, the guidance notes that have been produced are very helpful. They're very user-friendly, and would recommend strongly that you would take the time to read them. They're not very long, and it also then prompts you to go to the relevant important sections of the legislation. I think day one in law school, you're told the legislation is the source of everything, and so if there's any doubt, go back to the legislation and check the definitions. As you can imagine, dealing with a large number of clients as we are, we have been, notwithstanding the fact that Walkers has been involved on an industry consultation basis for a number of years in this process, we are now still working through the practicalities as to how these projects will be completed for for clients large and small, because there will always be different fact patterns that get to identifying the natural person, which is the ultimate aim of this legislation. But given the type of financial services that many of us are involved in, that's maybe not going to be the case in terms of what actually appears on a register. But as Andrew has said, the exemptions that have fallen away mean that at a minimum there will be informational requirements to be listed that are probably more than what has previously been caught. And then just to list out the actual percentage again for as a reminder, 25% is the relevant percentage here, not 10. So all of the AML people that are on the call that may have defaulted to the 10% point, 25% has always been the threshold for Cayman Islands beneficial ownership testing as it relates to beneficial ownership assessment, not beneficial ownership in the context of anti-money laundering. So if there's one takeaway from the session that you go back and speak to your colleagues on, I think that's probably an important one to consider, because apart from anything else, it will potentially mean far fewer in scope parties to be identified as beneficial owners for the purposes of this legislation. But after that mouthful, the definition is a natural person who owns 25% or more directly or indirectly of the Cayman entity, or as is more likely in practice, a person who otherwise exercises ultimate effective control or a senior managing official, which might be a director of the Cayman entity or an employee of the sponsor. So this is getting into the weeds a little bit, and is probably beyond the scope of this session, as much as I'm sure there will be hundreds of questions asking for specific advice on particular entities. Very happy to take those up after the call. Our details will be available, but that is something to bear in mind, that there will be certain straight line assessments that get to a live person, and we had some yesterday on calls that I was on, but generally speaking, it's going to be a little bit more involved in that. And then my final contribution for this slide is that trusts continue to be entirely out of scope. So we flushed that one out in the questions earlier on, but that is an important takeaway. Not trustees, trusts.
And just as we turn the page there, I'll just say the other important takeaway is, if you have Cayman Islands entities, and probably even if you have trust entities, you will need to, oh, it's all right, we can go on to the next slide, but you will need to think about this as a regime. I'm conscious that a lot of clients out there who have had fund entities who were out of scope wouldn't have considered this regime. Unfortunately, regardless of whether there is a bit of a benefit there, you will have to think about this regime.
Yeah, absolutely. So the alternative route to compliance is an alternative route to compliance. It's not an exemption. So it is potentially helpful, and something that we're seeing lots of clients definitely exploring. But I think maybe a point to make at this point in time is that it's not mandatory. An entity can opt to just follow the legislation as is written and as is prescribed for the fund entity itself, and actually maintain a register. There's nothing wrong with that, and there are many circumstances where that might be optimal for the client involved, or for your underlying clients. So that is not unusual based on the discussions that we're having, but the option to avail of an alternative route to compliance is something that clients have actually been quite interested in for a number of reasons and for a number of practical points. So the entities, what actions do you need to take? From a trust perspective, you're out of scope, no action required. Registered foreign company or other non-Cayman Islands entity, out of scope, no action required. As we discussed, a CIMA licensed legal person, that doesn't actually include registered persons. For any of you that, as I said, were exposed to those entities, there is an alternative route to compliance. CIMA registered mutual fund or private fund, except trusts, alternative route to compliance is a potential opportunity. A legal person listed on the Cayman Islands Stock Exchange, potential alternative route to compliance as well. Similarly, or an approved stock exchange. So that list of approved stock exchanges, I'm sure, is a website and a source that will be getting scrutinized very closely by people in times to come, to see if that is a potential option to use as an alternative route to compliance. Legal persons being wound up, legal persons liquidator or CSP must provide the competent authority with details of the liquidator and details of the legal person's RBOs at the time of the liquidator's appointments. These are all scenarios that are actually covered off in the guidance. And so definitely, as I said, legislation is king, But when you want to actually work on your book of business from a practical perspective, the guidance notes can provide quite helpful illustrative examples. Then legal person not falling above, not falling under any of the above, which already reports its RBOs. So as we said, Walkers have been reporting hundreds of thousands of returns over the last number of years, probably 6.5 years at this point in time. So a legal person must identify its beneficial owners under the new BOTA definition. And we'll get into that a little bit and provide a little bit more context around how the actual assessment as to who might be a beneficial owner will change. Its reportable legal entities and certain trustees, if any, and provide details of its RBOs to its CSP. So it's important to remember that the obligations here are actually on the company. So that is probably another key takeaway, and the consideration of the penalties that will be the last piece and the momentum to take away from the session is something that needs to be considered, particularly for underlying clients. We know that there are a lot of people on the call from the Cayman Islands who are operating in various service providers, and it is important to remember that it is an obligation on the entity itself, first and foremost, and that's not something that should be forgotten when it's being communicated to parties that you're dealing with. And then legal person not falling under any of the above, which is a very nice catch-all and is always the last refuge of the scoundrel lawyer to end the list with. So same as the above. So anybody that's not covered by the above list will actually need to comply with the requirements. The default position is that everybody is in, apart from trust, unless there's a reason that you have an alternative route to compliance.
And if we flip the page, this slide, if we flip on to the next slide, please, there we are. And this slide really is to talk to, we're going to talk a little bit more about the registered beneficial ownership. We'll have a little bit more of a breakdown into what that definition means. But really this slide, who is registrable? So who's going to appear on those registers, assuming you don't have an alternative route to compliance, as we just discussed? It's going to be either an individual that identifies as a beneficial owner, so that's relatively straightforward, so that's a human being, and this regime, I should say, is predominantly concerned with human beings. When we say beneficial owner in this context, we're looking for living, breathing human beings to be on this register. That's one of the it's one of those key sort of gating questions that we've been seeing a lot of, is can I put an entity down for a beneficial owner? And the answer is no. The next point there, just to directly contradict myself, is talking about relevant legal, reportable, I should say, legal entities. Now, reportable legal entities existed under the previous regime, but because the way it was worked, it didn't see much attention. It's going to be rather a more key aspect of this new regime, which is essentially another legal person, so another Cayman Islands person, that if it were an individual would be a beneficial owner of the first legal person. So essentially, if you are going up a chain from Cayman Islands entity A to its parent company B, Cayman Islands Company A will put Cayman Islands Company B as its beneficial owner. So it just hops up the chain, assuming that that second company there, that the parent company would otherwise be a beneficial owner. So that is going to cut down the amount of, if you like, information that's going to be being reported. It's going to make things easier from the perspective of registered office providers and from the perspective of the government. It will mean that within large groups, you will need to know who, where your Cayman Islands entities are and where they fall within a structure. So in this exercise, and we've seen we've been carrying out a lot of these. The structure chart is your friend here, and you can see up a chain of Cayman Islands companies because they'll need to report the reportable legal entity one step up the chain. It has some great benefits in the way in which it operates, because it means, for example, that if you are downstream of a Cayman Islands fund or another Cayman Islands entity that benefits from an alternative route to compliance, you will benefit from that, or your downstream entities will benefit from that. But you won't be sheltering under and calling your subsidiary down the chain a fund entity because it sits as a subsidiary of a fund. You'll be reporting reportable legal entities up the chain until you hit that Cayman Islands fund entity. But it's important to remember that this will be a key function of this regime that it hasn't been previously. And working out where your reportable legal entity relationships are, the structure chart is your friend here. That will help you
Yeah,
do that
absolutely.
analysis.
And where it's a very clear 100% ownership of another entity by a Cayman Islands entity who would have its own obligations, that's very useful and I think can be expeditious. There are certain scenarios that are covered off in the guidance where
Yes.
if there is information available or if you ask the question, does somebody otherwise exercise control? And Andrew is going to get into this in a little bit more detail as to how that can happen. There can be multiple entries required on the register, but that would depend on fact-specific assessments. And so it is certainly the case where you've got your structured chart with 100%, then you're listing all the way up. And with the caveat being that there needs to be a confirmation that there isn't something that you haven't been made aware of that actually sweeps aside that assessment. So it's definitely something that I think will arrive at efficiencies, particularly for larger groups. And I'm sure everyone has seen very, very involved and detailed and massive structure charts involving many different CAICOs on them. So it's definitely, as Andrew said, working through those documents very closely in order to form views as to who is exercising control will be important for entities that you are actually associated with.
Absolutely. And if we go on to the next slide, please. And this slide is just going to talk to who is a beneficial owner there. This is looking to a number of those specified conditions. So the obvious one there, direct or indirect ownership and control, 25% or more of the shares, voting rights or partnership interests. I'm going to come back to that 25% at the end of this slide. The individual otherwise exercises ultimate effective control, or the individual identifies exercising control of the legal person through other means. So your starting point is always that 25% threshold. Just to mention yet another threshold, when you're looking at indirect means, there is this concept of a majority stakeholder. It's not brought out in this legislation, in this slide pack, I should say, but what it is brought out is in the legislation and the regulations in particular. So if you are looking through to an indirect holder, an indirect beneficial owner, do remember to look and review that majority stake provision because it increases the threshold once again in certain circumstances up to 50%. So please remember when you're looking at indirect beneficial owners to remember to look at the majority stake test. We won't look at it here in any more detail than just flagging that for everyone because it rapidly becomes more complicated. I'm conscious that everyone's beneficial ownership structure looks a little bit different in any event, which is why, as Colin said earlier, we don't have time here to really get into the different permutations of it, but it is something we want to flag here about looking to that. Beyond that, as I say, you've got an ultimate effective control test. Do be aware of founders, people who have, founders in particular, people who have that level of ultimate effective control, people who otherwise might be considered to have that ultimate effective control. These last two tests, they are sweeper tests. They are designed to catch the sort of person who does otherwise have effective control over these types of entities. That's probably all I have to say there. So this might be where a lot of the complex analysis happens, but we'll switch over onto the next slide for now. And just as we talk, I can start talking to this slide. And there's a lot of information on here, but really the main point there. So the first point there refers to trusts. So as I said, trusts are out of scope, but you might end up considering trusts, and you might need to look to the trustees of a trust when you're looking up the chain, looking for your beneficial owner. The main point to pull off this slide, however, is that senior managing official. This is no longer a regime where it was under the old regime, and therefore it's a marked change. This is no longer a regime where you can come to the end point that there is no beneficial owner. That's no longer something that's allowed under this regime. You now have to, if you can't find a beneficial owner, based on the test on the previous slide, you have to look to a senior managing official. That is at the level of the entity in question. So you don't have, so having done your beneficial ownership look through, you don't have to start looking for that senior managing official up the chain. They are back at the level of the Cayman entity itself. Now, if it's a company, that might be a rather straightforward assumption of it is a director You only have to record one of your directors as senior managing official. Ideally, if you have some degree of hierarchy within directors, it will be the most senior, but you may not, and therefore it can be the most senior. You also have scope to record multiple directors if you wish, but you do not have to record all your directors there. If you have many directors at the level of that Cayman entity, you can record one, or you can have a couple share the burden of being the senior managing official there. It's a bit of flexibility around that point, but it is important to remember to bring it back down to the level of the Cayman entity and record that senior managing official, who will be a director or a director equivalent, someone at the executive control level of the Cayman Islands entity with which you are recording the beneficial ownership for. We're conscious of partnerships. That might be a less straightforward analysis than simply reading the register of directors, but that is the person you're looking to. And yes, we can indeed go on to the next slide. Thanks so much.
And as mentioned, this is something that is of particular interest to anybody that is working on or through Cayman Islands investment funds in particular. So providing written confirmation of legal persons to the authority, to the competent authority as follows. For CIMA registered investment funds, the CSP must provide the details of a contact person. For legal persons licensed under a regulatory law, the CSP must provide the regulatory law under which the legal person is licensed. For legal persons listed on the Cayman Islands Stock Exchange or an approved stock exchange and their subsidiaries, the CSP must provide the name and jurisdiction of the stock exchange. And for legal persons which are subsidiaries of an entity listed on the CSX or an approved stock exchange, the CSP must provide details of its parent's listing. So for getting in a bit more detail into the investment funds point, essentially that would mean a live person at the corporate services provider featuring on the register as being the person who gets the call, essentially, if you're to drill it down to that point. Yeah. And then the various obligations that would flow from that call actually arriving to that contact person are a matter that need to be considered internally as to whether or not you are in a position to meet those terms. And the specific requirements that are there are onerous in that they expect a turnaround within 24 hours. That's what's envisaged under the legislation. And so the contact person would need to be in a position to respond to those requests if this service is offered on a commercial basis. Also, there's an important requirement to keep information up to date. That's really peppered throughout the legislation. There is an ongoing expectation that entities will keep information current and up to date. That's not something for any of you that are working in compliance or ongoing monitoring. It's not something that's conceptually difficult. It makes sense that the information that is being reported to a regulator would need to be kept up to date rather than just being frozen in time as at the point of provision. And so where a legal person that benefits from an alternative route to compliance becomes aware that any information in the written confirmation has ceased to be true, it must within 30 days provide its CSP with an amended written confirmation correcting the erroneous information and providing any additional information required, and instructed CSP to file an amended confirmation with the competent authority. So that would be a little bit of client and corporate service provider working together. For instance, if somebody who was actually fulfilling the role of contact person was to change within an organization, then that would necessitate filings being made to the competent authority, which is, as we said, the general registry rather than CIMA. Then, again, not to labour the point, but I think it's important to be very clear that entities licensed or registered with CIMA for providing beneficial ownership information, typically CSPs, are who can actually fulfill the role as a contact person. So it's not a case that you can just stick up your hand and say, I'll be that contact person. That isn't actually what is in the legislation as to who is permitted. Notwithstanding the fact that you may want to do that, it's not actually something that's open to everybody to fulfill the role. It needs to be done at a party that is has sufficient permissions to actually engage with the registrar. In all likelihood, somebody that's already reporting from a beneficial ownership perspective information and has been for a number of years. Obviously, new licensees could apply to get into this business, but in terms of getting a license and setting yourself up in advance of the time when this would commence, we actually do act for people that are looking for licenses. So if that is something that you want to explore, please do get in touch. But the time frame might be a little bit tight at this point in time. So a fund administrator that holds a mutual fund administrator's license on the Mutual Funds Act is eligible to be appointed as a contact person. Ultimately, if you are attending this session and you're from an entity that is serviced by either a registered office in the Cayman Islands, which you will be if you're a Cayman Island fund, or indeed if you have appointed a fund administrator that is licensed here in Cayman, then it's something that you would wish to take up with your service provider if you did want to explore the alternative route compliance. And it is something that Walkers is offering for its registered office clients. So there are parties in the market that are actually going to do this on a commercial basis, but as we understand it, that's not the case for every service provider. Then the role of the contact person, and again, it's often sufficient detail. The contact person is a liaison who facilitates communication between the legal person and the competent authority. And then the contact person is not required to maintain a beneficial ownership register or beneficial ownership information, but must have access to it and report within 24 hours. And I think the practicalities around delivering that information within the time frame is something that is giving industry cause for concern before decisions are taken as to whether or not the service is going to be offered on a commercial basis.
Yeah, absolutely. If we click 2 slides on, Kimberly, that'd be wonderful.
Okay, before I do that, let's have a quick poll just to see who is listening. A little bit of a test here. So, Tom, if you don't mind issuing this poll, we're just kind of asking, based on what you heard Coleman Andrew just state, can any Cayman Islands person act as a contact person? We're looking good. Comprehension is high. So, yeah, we'll go ahead and stop that there. But yeah, about 85% are saying no. There's still a little bit of some confusion. 16% are saying yes. But again, we can hammer that point later. And do you wanted to go to this slide, Andrew, or another one?
The next one on, please. They're just the optimists. They just like clicking yes. It's just optimism, I'm sure. But other than that, good to see people are awake. So this is me. This is on persons who do not benefit from an alternative route to compliance. And remember, this is all on an entity by entity basis for the compliance of this regime. So even where you have, for example, we've got groups where even if there is a listed entity and they benefit from the strongest, if you like, alternative route to compliance for obvious reasons, there will be entities who do not fall as subsidiaries of that listed entity. It's no longer the case that whole groups will fall under one categorization that they can fall under. So even groups that are, whether they're fund groups, whether they're groups that sit below listed entities, it's likely you'll have entities that are outside of, that are not subsidiaries of those entities. So whether you're doing an RLE analysis in relation to those, or whether you're, as we'll discuss here, reporting some actual beneficial ownership information for those entities, that exercise will need to continue. So what does that mean? It means establishing and maintaining a beneficial ownership register. That means reporting those relevant beneficial owners once you've identified them. It's kept with the registered office provider, as we've discussed. It has to be kept with the registered office provider. There isn't an alternative there in terms of how that is kept. And indeed, those registered office providers have been working hard to liaise with the registry of companies to make sure that they're interface and interact, and make sure that they look right over that time period. You've got an ability there, or an obligation, to serve notice on RBOs where you don't have the information you think you need to provide. You need to provide the required particulars of those relevant for beneficial ownership. We'll talk to that over the next slide as to what that means. What's the information that's going to have to be provided for these beneficial owners once you've identified them? And again, that obligation to keep everything up to date. Typically, and it's there again, the time frame here within the legislation is 30 days. That's your typical time frame. That if there is a change There is a knowledge qualifier there, so if you don't know that someone's passport has expired further up the chain, you can't be expected to report it. But if you have a previous copy of their passport, you should know when it is expiring. But there is a knowledge qualifier on known or ought to have known in relation to changes further up the chain. But we will now go over onto the next slide there in terms of what particulars will be recorded and kept current on those registers once they're kept there. So you'll see there reportable legal entities, as we mentioned. That's going to be one of those important points for chains of Cayman Islands entities. So you can see there the various points there. Of more interest, I suspect, is for individual beneficial owners and what information they need to provide. So you've got full name and address, residential address, address for service if you need one, date of birth, nationality, information as contained on some form of governmental ID. So it's not necessary that we're going to be sending copies to the registrar of companies, but it's those data points. So it's the identification number, it's the country of issue, and it's the date of issue. How they, just to finish the point, how they have that and the date on which they became a beneficial owner.
I think the residential address point is actually something that has come up for us practically as well, where I think previously there may have been a provision of information that may have actually been business-related addresses. It's specifically stated here, it's not address, it's residential address. And that is something that might actually be a process change that needs to be considered when you're actually engaging in these exercises, particularly in the context of providing corporate service provider services. Rather than anything else.
Yeah, absolutely. And it's worth reminding everyone about that date of issue and date of expiry. When you are, I know there's a lot of registered office providers on here, and I'm sure you've all been thinking about this, but it is important to have a process that tracks the expiry of those documents that you're collecting, because that is a change. And we did see before from the previous regime, it was considered that once those regimes had gone out of date, there was a need to go back and update them. So just build that into the systems. It's easiest done, once you've got that date of expiry built into an online platform. You can see when it expires. There should be a flag popping up. Just to build that point in, because we know from historically we've seen that's been one of the pain points implementing the regime.
And then on to the next slide, please, Kimberly, on the corporate service provider obligations. And I think probably the high number of people who answer 10% means that a lot of people are AML people on the call. And I guess makes sense given the title of the actual session as well. But it is certainly something that is maybe newer to people who are not operating in this area around ongoing monitoring and keeping information up to date. It probably goes without saying that we're people who are in this on an ongoing basis it makes perfect sense to draw that point out. But particularly when you're speaking to your colleagues, that tracking of the data is very important. The content that's on this is essentially the practical steps that a corporate services provider would be obliged to take. Ultimately, the uploads of the information at least once a month to the registrar on behalf of the corporate services entity are very important. I know as a matter of practice that multiple uploads per month are being completed as it currently stands, and I can only imagine that will be something that will happen more frequently as there's more data to actually handle and manage as more entities come into scope. And there are record keeping obligations as well, the good old 5-year record keeping information, which is the same as under the anti-money laundering requirements. Next slide, please.
It's back over to me for who has access to the beneficial ownership information. Now, at the moment, as we speak today, there is no public access to the beneficial information. We know that there will be coming to force some ability for persons with legitimate interests to request access to certain of the information retained subject to various safeguards. We know that is currently in consultation as to what that will look like. At the moment, this is not a public beneficial ownership register, and even with those legitimate interests allowed for, it will not be a public beneficial ownership register for the time being. But it is worth, it is worth remembering that There will be some ability for certainly counterparties, for example, to potentially gain access to some of this information. That is it's an open item for the time being. It's an area of the regime that is still being given a lot of consideration. It's possibly the most sensitive area of this regime, and therefore that's why it's been why we have so much of the regime that is now in force and will be, of course, coming into force again 1 January 2025, and yet that particular piece is still being considered and consulted on. For the time being, you've got the various Cayman Islands entities that can access this information. There's no surprises there. Financial Reporting Authority, the Monetary Authority, Anti-Corruption Commission, Tax Information Authority, and a few other various authorities there in relation to that might need to be able to gain access to this information. There's any surprises there in terms of the types of government entities within the Cayman Islands that might well have access to this information. But just remember, everyone, to keep in mind that legitimate interest point. It's one that we'll all be looking at over the next few months.
Yeah, definitely. It's something that Andrew is actually involved in the consultative groups for as well. So there certainly has been a strong voice of industry on the consultative processes. And moving on to that next slide, I think it's why are we here is probably a good place where we could have actually started this. The reason that this has been proactively adopted has been a bit of a change. I think that, again, many of you on the call will have seen. There have been other instances where legislation may have had to have been implemented by certain dates as a result of international standard setting bodies requiring the Cayman Islands to get involved and do something. This has been very much a proactive, ambitious project by the government to put the Cayman Islands in compliance with an agreement made with the United Kingdom back in 2016, the so-called exchange. The agreement with the government around exchange of notes, beneficial ownership information. So it actually is bilateral between the United Kingdom and the Cayman Islands as to where we are here, which if you compare and contrast maybe around the FATF or the OECD, those are international standard setting bodies. So this is slightly different. But to Andrew's point on the consultations related to legitimate interest and those kind of things, those principles will ultimately be formulated on what the international standards and practices are. And many of you might be familiar with the European Court of Justice actions in this area around the privacy of individuals, around publicly beneficial ownership registers. Any of you that are dialing in that have maybe worked in Europe or in other jurisdictions where registers are more freely available, may actually find it a bit odd that there isn't some element of public access that you can go and check who a director of a company is. But the islands and the government of the islands have made efforts to meet international agreements in this, and also then to sensibly get involved in assessing what a legitimate interest might look like as and when it becomes appropriate to make the various legislative orders to switch that component of the regime on. It is something I think as regulatory lawyers we get asked on quite a regular basis, fundamentally around whether or not people can actually check the registers as it currently exists, and then also what the direction of travel might be. And so I think it's important as a takeaway to realise that there will be legitimate interest components to this.
There will, but at the same time, the Cayman Islands will and is constantly assessing what the international mood is and what the international desire is. We are under scrutiny from various international bodies, not just the UK, and being aligned with the international community has always been the sort of first and foremost at the forefront of the Cayman Islands thinking when developing this type of legislation.
Yeah, absolutely. So I think it's very important to note that this is part of international responsibilities of the islands and demonstrates the government's commitment to meeting those obligations, whilst at the same time keeping industry involved in the consultative process for formulating those approaches and making sure that everybody has an ability to contribute an opinion or a view or to provide international best practice as a base level and from a feedback perspective.
Exactly. And over onto the last slide, please. Yeah, there we are. So failure to comply. Unsurprising, there are offences and penalties here for failure to comply. It's worth remembering that you've got a range of fines there on screen, so 5,000 to 100,000, and potentially some criminal penalties as well, some potential imprisonment there for really high-level offenders. There's administrative fines there as well, which are probably the more real threat here. And you can see on there 5 to additional fines of 1,000 up to 25,000. It's worth remembering that if it remains unpaid, you can move to a strike. The registrar can proceed to a strike off. And remember, it is the registrar of companies that deals with that. There isn't a barrier there. They can simply progress to that strike off action if and when they need to. These are administrative regimes, and therefore it's considered that administrative fines are appropriate as and when there is a fault or a breach, and therefore it's worth remembering that this is a regime. These are areas where we have seen enforcement action over the years under the previous regime, and unless and hoping there is considerable and substantive compliance across the islands, we wouldn't be too surprised if that's not the case to see penalties in the future.
Absolutely. I think in an overall sense, we provide training and things around all of the requirements of Cayman Islands entities from a financial services perspective and an economic substance, etc. And the credible threat of enforcement is something that is indicative of a high-performing international financial services jurisdiction and is just part of doing business. It is certainly the case that where people are taking the effort and time to comply, that there is a downside to not actually taking that pragmatic approach. So it is something that we have seen develop over the last 4 or 5 years, probably, and as Andrew said, more specifically in the last 2. So I think that's the content done and dusted.
3.5 minutes for questions.
Yes, indeed.
Exactly. And unfortunately, there's some pretty complex questions. I did want to let everybody know who is listening in. And just so you know, we have just over about 650 people listening in, so I am not going to get to all the questions. I'm already looking at them here. You do have a great website called Walker's Insights, so you can get some information. I'm sure Andrew and Colm, you'll be providing more information there too, correct?
Yeah, absolutely. The website is the best source for the most up-to-date information, because we're going to update FAQs and decision trees, and as the thinking becomes more crystallized on various issues, we're going to provide updates and pieces on that.
Okay.
And
all right.
we're delighted to on an individual basis as well.
Okay. I'm just going to, before we go, because we do have some Silo users. So for our Silo users, we are working on, we're calling it Bowtie, and it's going to be an app that helps you kind of, get this information from your client entities. So I will be letting you guys know about this new app and showing it to you guys. It's just going to allow all the batch processes, and then they're going to be able to, send that information, and it will then upload into Silo and keep your beneficial ownership registers up to date. And of course, as you all know, we already have that like passport expiration notices and stuff like that too. So please do keep an eye on that. And if anybody else outside is interested in something like this, do please let us know. So I just wanted to add that real quick, and let's go to so these are some pre-submitted questions from some of our regular attendees. I know we've only got a few minutes. Are any of these one that you would like to answer specifically live, or maybe we could address them in the follow-up emails?
Yeah, this is going to sound like a real straight bet, but I actually can't read them because the screen is about 20 feet away from us. The camera is actually quite zoomed in at a suitably far away to catch blemishes, but suitably zoomed in to the extent that we actually can't read the questions as they currently are written.
I'll read one. The first one is there a requirement under BOTA for an in-scope entity to report a senior managing official where a reportable legal entity has been identified and reported, but no beneficial owner has been identified? And from what I'm getting from you guys, the answer is yes, that they would report the director or senior management.
No asterisk.
Okay. And then the other question is, how would you go about classifying and identifying a registered beneficial owner and a nominee investor ownership holding structures? Sorry, my phone just went.
Would you repeat that one again, Kimberly? Just want to.
Yeah. So they asked, how would you go about classifying and identifying a registered beneficial owner and a nominee investor ownership holding structure? And it could be that it's a bit complex, and we maybe need to kind of tear it apart offline.
Like it fundamentally, when you strip it back,
Yeah.
like you start off trying to get to a live, warm-bodied person who owns 25% of the entity, and really moving away from first principles is probably the enemy of this in making it too complex from the outset. But Andrew has just gone to the relevant slide there.
Worth thinking about ultimate effective control in a nominee situation, say.
Yeah, and actually, the person finishes the question with, how would you go about classifying of a 25% nominee investor in a Cayman investment fund? But wouldn't a Cayman investment fund be?
It depends. If you have the alternative, then you would have to probably have that information in the background, but it would just follow the normal rules.
Yeah.
Okay. And the third question is, in regard to an official liquidations where beneficial ownership documents cannot be received, what is the best way to go forward with the new act? Would it be best to put pending? But did I realize you can only do that for 90 days?
It's worth saying there are some provisions in there around what to do in relation to a liquidation. Please do check the guidance.
Yeah.
I won't try and paraphrase in memory, but there are provisions.
Details of the liquidator, details of the legal person's RBOs at the time of the liquidator's appointments that's actually on one of the slides.
Yeah.
Okay. Under the next question was under the old regs. You had to confirm the date the required particulars were confirmed. Is that who is required to record the date that the particulars are confirmed? And I think the new regs kind of use the phrase verified, because I noticed that change too. But is that the legal entity themselves, or does the CSP? Because the CSP has this wording that it's got to verify the information.
I think we'll pass on that one only because I'm conscious that that's talked to the file essentially, and it's a question best answered with the CSV file in front of you in terms of what the registered office providers need to submit.
Okay, great.
I think this is when to issue. I can just read the last one, when to issue a notice. Yeah. Relying on some eyesight there, which it's become almost an eye exam, this, for both of us, I think. I think the answer there as to when to issue a notice, if you are, I'm conscious that we haven't mentioned it in this presentation, and the old concept of restrictions notice persists into this new regime, and I'm conscious that was, that had implications under the previous regime, and it will continue onto this regime. It is the BAT that enables, potential beneficial owners to, if they are being obstinate about providing beneficial ownership information, you can threaten to issue a restrictions notice. There are provisions in the legislation. I'd urge everybody looking at those restrictions notices to consider in great detail before they go ahead and utilise a restrictions notice. But I won't go into any more detail there because frankly, it's a complicated process, and the ins and outs of it are set out in the legislation.
Okay, great. So we're already 4 minutes past the hour. I don't want to take up any more time. I'm sorry for those of you who posted your questions in the platform. I will go through those and see what I can do. I might even, Andrew and Colm, see if there's any of them that you can kind of help us with. But I want to thank you again so much for giving us this hour. It was packed with information. I could tell you knew that, and you were trying to get through it as fast as you can. So again, our silo users, follow up with us on this new application that we are developing to help with this. Tom or myself will reach out to you. And our next webinar session is going to be about AML training and its impact on operations. So, and how important, well, in just about any kind of training, anything like from beneficial ownership training to AML training and cybersecurity training, and give you some structure on how to create some very good training programs. That's in October, so please watch out for that email. And again, thank you very much. And for those of you who have been following us for a long time, you, of course, will notice we have rebranded. I hope you like it. And Colm, Andrew, thank you so much. And I hope you guys will come back and help us maybe delve into some really these kind of nitty gritty, like the notices. And as kind of problems arise, and you know, if you don't mind, I'd love to have you come back in a few months and help people kind of, you know, get through some of these messier parts that might be more difficult. Yeah, fantastic. I appreciate that. So again, that was Colm Dawson, and you can reach out to Colm with his email, and Andrew and Tom Gardner, anything Silo related, you can reach out if you're wanting to know more about Silo. So thank you again.